All right, thank you everyone for joining us this afternoon. My name is Jay and I'm the office manager here at Standpoint. So my role today is going to help facilitate this webinar. So if you have any questions during the presentation, please, you can type your question in the chat box or you can use the Q&A tab as well. And I'll pass the question along to our presenters today. Most of you probably know a little bit about our organization already, but for those that are listening later on YouTube, we are a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are our annual new laws throughout the state of Minnesota, which registration is now open. You can go to our website and sign up for new laws. We also have monthly webinars for advocates such as this one and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors and our advocates connect callers with resources, safety plan, listen and help callers identify possible options and next steps. This webinar is being recorded. You can check it out on our YouTube page following this webinar. It'll also be mailed out to our legal advocates listserv if you're on that listserv. And for today's presentation, I'm going to be sharing in the chat box a link to the Dropbox materials. If you can follow along with the PowerPoint, there's other handouts in there as well. Now I'm going to introduce our two panelists today. First, we have Beth Assell, who joined the Standpoint team as a staff attorney in October 2020. Beth graduated from law school at Hamline University and directly after graduation clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in these fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps and brings the standpoint of lifelong passion for advocacy and helping others. Rachel Kohler went to law school at Hamline University and has been working primarily in immigration law since 2009. As an attorney, Rachel worked at Southern Minnesota Regional Legal Services, providing assistance to those going through the citizenship and naturalization process, and has clerked at the Immigration Court and at several private immigration firms. Rachel worked in Anoka County for 2 years and dealt directly with civil, family, and criminal cases. Rachel joined Standpoint as a staff attorney with an immigration focus. So now I'm going to pass off the reins to Rachel and Beth. Thank you.
Thanks, Jay. So I'm going to use this goal slide as an opportunity to tell everybody that Beth and I have a very ambitious agenda for the presentation today. And we're talking about immigration, and I know that is scary for a lot of people. And so please do put questions, any questions that you have in the chat box or in the questions, the Q&A tab, but also know that we're not going to test you at the end of this. We have a lot of really helpful handouts that we're going to kind of call out as we go through the presentation. So you'll have materials to go back to. You can go back to this presentation. It'll exist on YouTube, but also like Beth and I will exist. And so you can always pick up the phone and call us if you encounter a situation where you vaguely remember us talking about it in a presentation and you want to talk to us in person. And so we're over the phone. So I think with that, I'll just go to the next slide. Is that okay, Beth?
Sounds great. Yep. Okay, so this slide is directly ties in with our first goal, just trying to give at this point an overview of when immigration status can and cannot be relevant to a family law case or a civil protection proceeding. So as an overview to start, immigration status, or excuse me, a family law case can be a really good resource for your client to obtain helpful evidence for an immigration case. So some examples of that are obtain SIJS, Special Immigrant Juvenile Status. Status is the last as right, Rachel? Okay. Findings for abused immigrant children and certifications in immigrant crime victims, U visa cases. In an immigration case, it can be incredibly difficult for your client to obtain evidence that may be helpful to them in that case. There's no discovery or a way to compel a court order. Your client who you're working with might find themselves just kind of trying to get information from their abuser if they're in an abusive situation, and that's not likely to be successful. So if they are in a family court proceeding at the same time as they're going through the immigration process, that can be a really great resource for them to gather helpful information for things like that. And then just in general, tying immigration, when immigration status can be relevant to a family law case or civil protection proceeding, is that there can be immigration consequences that can come from those types of proceedings. For example, if there's violations of a protective order in place, or if there's findings or admissions of abuse on the record, that can come into play in an immigration case, as can contempt or jail time. But those protective orders, those civil protective orders, is also a good opportunity for a client to ask for some kind of creative remedies to also help them in their immigration case. And we'll cover that more later in the presentation.
And in a future slide, we're going to talk about all the ways that immigration status is not relevant. And I would say for the most part, that possible immigration consequences section is not meant to scare people away from going through a divorce or getting a protective order. I would say, like, in most cases, there is absolutely no reason your immigration status should come into play. And Beth is going to talk about that more later. But obviously the violation, so if a protective order is issued against the victim that you're working with and they violate, that's a criminal action. And now if you have a criminal action, a charge, a conviction, that's obviously going to, you know, potentially have implications for immigration status. But sort of something that people don't think as much about is like findings or admissions on the record. So for example, if you go through a protective order and they make a finding of abuse, while there is no conviction, there's no criminal charges, the fact that there has been a finding made that this person has been abusive, immigration will often consider a person's good moral character in deciding whether or not they want to grant them an immigration benefit or not. And if there is something like a finding of abuse in a public record, that is something that immigration can use in determining whether or not a person is a person of good moral character as defined under the Immigration Act. And also, obviously, like if you having a family law case isn't an issue, but if you violate an order and you're held in contempt and you have to go to jail, jail time is also something you have to disclose on a lot of immigration applications. So again, these are kind of like extreme circumstances where maybe your client won't have to deal with that, but we just wanted to make clear that there are times in which it could implicate or affect a person's immigration status.
So when else can an immigration status be relevant to a family or civil protection proceeding? As many advocates know, because they've been helping guide clients through the family court process, per Minnesota statute, domestic abuse is relevant to a lot of things in family law. Like we have listed there, custody determinations, the best interest factors when determining parenting time, and then topics like relocation, if a parent wants to relocate out of state with children. So domestic abuse is very relevant. And so if victims are experiencing domestic abuse based on their immigration status, that can be evidence of abuse in power and control that they have suffered in their relationship. So some examples we have listed here, things that we've seen or heard from callers. If they are someone without status and their abuser will make threats that they will not file their immigration papers or they'll withdraw them, or their immigration status has been made a part of their history of violence. For example, their abuser will threaten to have them deported, threaten to take the children from them because they don't have status, threats that police or courts or other professionals won't intervene and won't help in the event that the person without status calls for help. And so if that's something that's happened to a client of yours, those are examples of things that can be raised. For example, in the divorce, if they're asking for sole custody or for some kind of restricted parenting time, or in an order for protection, is an example of the history of abuse.
In general, I feel like when I talk with folks, I'm telling them, like, don't bring up immigration status. It doesn't matter for the family court process. But these are really good examples of how, like, a person's immigration status or lack thereof can be used as a tool for abuse. And if you're trying to show abuse in these custody determinations, in the best interest factors, that sort of situation, it could be very relevant and very helpful for your client's case.
Yeah, but there are times where I think, like Rachel said, it shouldn't, immigration status should not come up in certain areas of a family law case because it absolutely is not relevant. Not having status has nothing to do with your eligibility for protections under a family or civil court. It should have nothing to do with the evaluation of your client's parenting skills or fitness as a parent. It should have nothing to do with child support determinations in the sense that someone without status can still receive child support. Someone without status, if they're working, can still be made to pay child support. And then similar to under evaluations of parenting skills and fitness, it is not part of the best interest of the child determination. Nothing in our best interest factors in our statute lists immigration status or English competency as a factor. And that's not to say, none of this is to say that if there's an abusive party in this proceeding, like the other party is an abuser, this isn't to say that they're not going to try to use a victim's immigration status against them. Like Rachel was saying before, that's unfortunately a very common form of intimidation and abuse, and I don't see that stopping, unfortunately. We're just saying that when a court is deciding custody and parenting time, they have to look at the statutory best interest factors. They have to consider whether or not domestic abuse is a factor in the relationship, and a parent status in this country is not a factor. And so one case we have highlighted at the bottom there, State v. Maria L., otherwise known as Henry Angelica L. It's a case from the Nebraska Supreme Court. It was a unanimous decision from that court. And so limiting factors in the sense that it's not a Minnesota state court, and this had to do with a termination of parental rights cause of action rather than a family court. But I think it still has some important language there that can maybe help guide someone if their immigration status is trying to be used against them by an abuser. And basically that decision just affirmed the constitutional right of immigrant parents to care for, have custody of, and control over that their children. The party in that case, Maria, was a Guatemalan woman who was deported. And the court made some good findings, like they concluded that her attempt to bring herself and her children into the US in the belief that they would have a better life here does not show that she lacked concern, care, or judgment for them. So they didn't buy into any attempt to use that against her. And they said that the best interest of the child standard doesn't require that they determine that one environment or set of circumstances is superior to another. So in that case, I think the county was trying to argue against her that in part because of her status and what had happened to her because of her status, that her home wasn't as good for the kids as another home could be. And so it's just affirming that status and couldn't be used against her. And just in general, helpful language about requiring all the steps that this particular parent took to better herself and care for her children in spite of obstacles. And that obstacle included her immigration status and a system that seemed to be working against her. And so I think a lot of advocates who are listening to this likely have had a client who has been working against those same obstacles, and just know that that's something that a court should not be using against them.
All right, so the next presentation is kind of where I take over and I talk for a long time. So this is the kind of immigration heavy part of the presentation. I will try to make it as painless as possible. But I'm going to start with my most challenging slide, I think, of the presentation, in that I have 6 different immigration options here that can maybe more likely come up in a situation where you're dealing with family law issues and immigration law issues. So I have done presentations on these things in a lot more detail. I'm not going to do that today, but I am going to talk, I'm going to try and give like my 1 minute or shorter synopsis of each of these kind of options to just generally lay that out for folks. So the first one on the slide is a vow of self-petition. In an ideal situation, if you are married to someone with status, you are the parent of a child who has status, or you are a child with a parent who has status, that family member with status will file a family-based petition for you, the immigrant person, to get immigration status. However, when you're dealing with abuse alongside of sort of a family law situation, there are a lot of reasons why abusive family members might not file, or they might file and then not complete the process or withdraw. It is as we've talked about already today, it is a way of maintaining power and control over a person. You know, if you don't have immigration status, your options to leave are limited, your options to work are limited, your options to get a bank account, to rent, I mean, you just are, you know, there's a lot more challenges to daily living if you are a person without immigration status. You rely a lot more on that other person. And so in those circumstances where the family member isn't applying for the family-based petition or isn't completing that process, the abused immigrant person can file for their own petition, which is really unusual in the immigration context. You usually need an anchor, someone like applying for you to get status. But in this case, as long as you can show that there was that valid relationship, so I have listed on there, if you are a spouse or a child, that relationship has to be to a US citizen or green card holding spouse or parent. And for abused parents, it has to be US citizen children. So green card holding children isn't sufficient. But you can file for your own petition and not relying on the family member if you can show that valid relationship and you can show that there was abuse. So if you're a child or a parent, usually that's shown through like birth certificates. It gets more complicated when you're dealing with spouses. You can show the marriage certificate that you're legally married. It does require a legal marriage, not just a marriage, a common law marriage, or like a religious marriage. It has to be a legal marriage. And you also have to show to immigration that you got married in good faith. Immigration is always, that's going to be a theme in all immigration, is that immigration is very worried about people getting married solely for the purpose of getting a green card. So part of the vow of self-petition, if you're a spouse, which is how I see them most often, is to prove that that marriage was legitimate and that there was abuse in that marriage. So that's the vow of self-petition. And the ideal, if you get the vow of self-petition approved, you'll be able to apply for a green card kind of through the vow of self-petition. A battered spouse waiver is what happens when you get a green card that is conditioned on marriage. It's a marital green card. So if I get married and my marriage is less than 2 years old when my spouse applies for me to get a green card, I'm given a conditional green card that's only good for 2 years. It has conditions on it based on that marriage. If we were married for longer, if we'd been married for 10 years by the time I got my green card, I wouldn't get a conditional green card. It's only for people who have younger marriages. The point of that is, again, immigration is so worried about everybody getting married to get green cards. So if your marriage is young, they'll tell you, we're giving you this 2-year green card. After 2 years, you and your spouse will file an application together, jointly, to remove the conditions on that green card. So you're going to reprove to immigration, hey, look, 2 years later, we're really married. We filed taxes together. We have a dog. We have 2 kids, you know, whatever you need to prove to show that you are in a legitimate marriage. And at that point in time, they would remove the conditions and give you a permanent green card if it's approved. So what happens if you are in a bad relationship, abusive relationship, when you've separated? There is something called a battered spouse waiver. So it's a waiver of the joint filing requirements. So normally you have to file jointly together. This says, okay, there's abuse. So I'm asking not to file with my abusive spouse. I'm asking to remove those conditions on my own. I still, like the vow of self-petition, have to prove my marriage was real. I still have to prove all of that and prove the abuse. And if I do that, I would be able to get a permanent green card, 10-year green card, not based on marriage, without the participation of my abusive spouse. So that's a battered spouse waiver. Vow and battered spouse waivers are pretty similar in the kinds of evidence immigration is looking for. So they're different processes, but I'm going to kind of group them together as it relates to like collecting evidence. I swear those were the 2 longer ones. Special immigrant juvenile status, it requires this is why it's really important for this presentation, it actually requires involvement of a state or juvenile court. I'm going to talk more about what that means and what participation is required later in the presentation. But a state court action and order is required. So that state court order has to basically say that this child, for the purposes of immigration, that's age 21 or under, cannot reunify with one of their parents because of abuse, abandonment, or neglect. It can be by both parents, it can be by one parent. With that court order, they can then file that alongside of an immigration application and get something called a special immigrant juvenile status, which then allows them to apply for a green card. So that's SIJS, or special immigrant juvenile status. The U visa is probably the one people are most familiar with. If you are a victim of a certain crime, and it includes many domestic and sexual violence related crimes, the U visa was really created for domestic and sexual violence crimes, but it includes some others as well. So they have to be a victim of a certain crime. That crime has to have occurred in the US. They have to be helpful in the investigation or prosecution of the criminal activity. So they have to report it to somebody who can investigate the crime. And the really important part about that is that law enforcement, whatever law enforcement we're talking about, has to sign a form certifying, yes, this person was a victim of this crime. Yes, they were helpful in the investigation or prosecution. And that certification form filled out by law enforcement is a requirement of the U visa. Can't apply for it without the certification. So that's one of the really important pieces of evidence you might be able to get in like a civil protective order action. We're going to talk about that in a little bit. And you have to have experienced harm as a result, which doesn't necessarily have to be physical harm. It can be emotional harm. It can be psychological harm. A T visa is similar to a U visa in a lot of ways, except for its victims, or specifically victims of human trafficking, both sex and labor trafficking. Again, it has to occur in the United States. You have to be helpful in that investigation or prosecution, but unlike the U visa, it doesn't require a certification. So while helpful evidence might come out of a civil protective order case or a family law case, I'm going to talk about T visas probably a little less in the presentation. An asylum is when a person cannot return to their country of origin, their home country, because they fear harm due to race, religion, national origin, political opinion, or membership in a particular social group. Importantly, domestic violence or gender-based asylum falls under that membership in a particular social group section. And recently, kind of excitingly, during the last administration, there was a really unhelpful court opinion, which really cut back on the amount of domestic violence-based asylum applications. It made it a lot harder to get asylum based on domestic violence. That ruling was recently reversed. And so that's now something that we don't have to deal with. It's still hard. Asylum is still a hard form of relief to apply for, but hopefully it's become a little bit easier as it relates to domestic violence. And we're not going to talk about asylum as much today either. It doesn't apply quite as much, I don't think, but just so you know, as advocates, asylum generally has to be applied for within a year of entry into the US. So if you're working with someone who might be eligible, better to get them in touch with an immigration attorney sooner rather than later. Oh, that was a big slide, Beth. Okay, so the next slide is me too. So this slide kind of details, I'm not going to go through it in extraordinary detail, but this is helpful immigration evidence that you might be able to get in a protective order or family law case that might help your immigration case. And so this evidence is specifically related to that VAWA self-petition and that battered spouse waiver, because oftentimes it requires you to prove that your abuser, usually your spouse, has legal status. That can be hard if you don't have access to their passport, their green card, their birth certificate. You have to have evidence of that legal marriage. Again, marriage or divorce certificate, the fact that you're listed on their health insurance, the fact that you guys have a bank account together, that you have a mortgage together, or you're on a lease together, that you file taxes together. You also have to show that your marriage was in good faith, that you didn't just get married to get a green card. And that can include, yes, birth certificates, tax returns, but it also can include photos of a vacation you guys went on, birthday cards that you gave each other, because that's the kind of stuff that comes out of real relationships. And It's not unusual that when someone is fleeing their home, is fleeing for safety, that they're not thinking to bring all of these things with them. And then, of course, through the process of like getting a protective order, testifying, providing affidavits, you might be able to get evidence of abuse or extreme cruelty, all of which is necessary for both the battered spouse waiver and the vow of self-petition. All right, moving on. Additional evidence that you could get in a family court action could be a U visa certification. Normally, when people are thinking about U visa certifications, they're thinking about police, which makes a lot of sense because most of the time, I would say U visas come out of a report to police. The police department is the one signing that U visa certification form, that I-918 Supplement B. But maybe what people don't know as much is that the immigration statute lists law enforcement as being far more than just police. So law enforcement can include federal, state, or local law enforcement agencies like police. It can include prosecutors on criminal cases. It can include family protective services, and it can include judges in state court actions like in protective orders. In order to get a U visa certification, like I said, you have to show you're a victim of crime, which can include domestic abuse, domestic assault, that they possessed information, so that they had information to provide about their victimization, and that they were helpful in that investigation or prosecution. That's maybe where people are like, oh, but wait, in a protective order, is it really an investigation or prosecution? Well, the immigration statute defines investigation or prosecution to include the detection, investigation, prosecution, conviction, and sentencing. So even detecting a crime and being helpful in the detection of that crime is sufficient to be helpful in the investigation or prosecution. So detecting crime, detecting domestic abuse, such as in a protective order case, is sufficient to provide the requirements for signing of a U visa certification. Helpfully, in 2015, the Minnesota Board of Judicial Standards wrote an opinion specifically about judges signing U visa certifications in protective order cases. And it was pretty supportive of the idea that judges can do this. The only time they were a little wary about it is if the judge lacks sufficient basis. So if the judge is uncertain if the victim actually has been helpful in detecting that abuse, for example, if like the victim doesn't appear at the hearing or the victim refuses to testify, those might be reasons why a judge may not find a sufficient basis. But as long as there's a sufficient basis, a judge should be able to sign a U visa certification in an order for protection case. So one of the many handouts that we're providing you today is that judicial opinion. So if it's something that you're trying to work with your client, trying to get the certification, providing that judicial opinion to a judge when you're requesting that might be very helpful. And I just keep going. So more evidence in special immigrant juvenile status cases. So like I was saying a few slides ago, a state court order is required in a special immigrant juvenile case. So it's the perfect marriage of family law and immigration law. You need both pieces. So in immigration law, so many immigration definitions, they say you need to have special findings by a juvenile court. How they define juvenile court in immigration law is a court in the US having jurisdiction under state law to make determinations about custody and care of juveniles. So that can include juvenile court, but it can also include family court. It can also include child protection. It can include probate or guardianship. It can include kind of a wide variety of state law cases, including like a divorce or a protective order. And so the specific findings that a judge has to make is that one or both parents are not viable to reunify with the child due to abuse, neglect, or abandonment. In immigration, they call that the predicate order. And so it is important, if you're working with a client who you think might be eligible for special immigrant juvenile status, to get that family law attorney and that immigration attorney together so that the immigration attorney can talk with the family law attorney about the specific findings that need to be made in order for that person to then be able to apply for special immigrant juvenile status. Because it is like very specific, the language that immigration is looking for. So you really need to have that really specific language in the order. And then I think there's a really great case that Beth found that is going to talk about. Talk about that.
Yeah, there is indeed a really great case. So the one we have listed here on the right side of the screen, this time a Minnesota case, Minnesota Court of Appeals from 2017. And so in this case, the mom with kids, both of them, both mom and kids, were abused by the father. She filed for divorce in Minnesota in 2016. And she was incredibly smart, thought ahead, and in her petition for divorce, she specifically requested not only sole legal and sole physical custody of her kids, but she also specifically requested that the district court make these findings that Rachel talked about. So she put that in her petition, asking the court to make these findings necessary for the kids to seek SIJS status. And in this case, at the district court level, dad defaulted. So he, was served, but then didn't come to the hearing. So mom got to proceed without him. And even with that background, the court refused to make the SIJS findings. In that judge's opinion, sole custody to mom was not sufficient to meet the burden, and divorce was not the appropriate forum. I guess it's not super surprising that court was just saying, I don't want to get involved in that. That's not for family court. And mom, again, super smart mom, appealed. And she said, yes, the sole legal, sole physical custody to me, plus the request I made in the petition for you to make these findings is sufficient, and the Court of Appeals agreed with her. So now the law we have from that decision is where a district court finds that children cannot reunite with an abusive parent and makes an award of sole legal and sole physical custody to the non-abusive parent based on those circumstances of the abuse, we must conclude that an SIJS dependency/custody finding is merited. And then they're noting that doesn't impact the kid's immigration status, maybe to kind of calm down family court judges, like you're not getting overly involved in immigration, but you're just permitting that immigrant youth to move to the next step in the SIJS status. And so it was remanded to that district court to make those findings. And so just some practical tips from that case is if you are working with a client who they are going to be part of a family court process and you feel like this SIJS may be relevant to them and their children, ask them to inform their attorney up front or consult with an attorney if they're not represented by one about how to incorporate that request into the petition so that if the case goes by default, or I suppose even if it doesn't, that the other parties on notice that this is a request and they can ask the district court to grant it. If they've already filed, they can ask him to amend the petition. And a Maryland court found in a case just like that where the non-abusive parent hadn't included it, but that amended it, that the amendment was sufficient and there's no need to file a whole separate motion when the request is made. Just putting it in the petition makes the intent perfectly clear, and that's acceptable.
Awesome. Great case. I love that it's from Minnesota, and so it's really relevant to the cases that we're working on that there's been a finding. I did just want to correct myself. I said that you could get a predicate order in both a family law and a protective order case. I am very doubtful that a judge would ever make this finding in a protective order case that is so permanent. And so let me amend that and say this makes more sense in a family law process than it does in a protective order. We all make mistakes. Right? All right, now confidentiality. So as we're talking through this, people might feel a little uncomfortable because we're talking about bringing up immigration stuff in a family law context. And are we opening the door? Can the abuser or the abuser's attorney ask for the immigration file from the immigration attorney? Can they find out about a VAWA petition that they're filing for, or U visa application that they're filing for? And thankfully, Congress has anticipated this, and they created something in the Violence Against Women Act around confidentiality protection specifically related to these immigration cases. So there's federal law that states that an abuser and an abuser's family cannot, and third parties, so that it would include defense attorneys, it would include family law attorneys, cannot get information about the existence of a case, about any action taken on a case, or any information contained in that case file. So at Standpoint, I'll get calls from family law attorneys saying, hey, the other side is requesting, discovery of this immigration file, like what should I do? And my advice is to invoke this, citation here, these VAWA confidentiality provisions. People are also worried that they might try and call immigration to see if the other person can be picked up by ICE if they're not in the country with authorization, or try and get information from ICE. When you file an application based on abuse, so like a VAWA self-petition, a battered spouse waiver, U visa, T visa, Department of Homeland Security, which is sort of in charge of all the immigration stuff, they put a special code on all those applications, which basically indicate that very selective people can get any information about that immigration case once it's filed. So thankfully, this information is pretty well protected. So if that ever happens to a client in a case, this is the confidentiality provision in the citation I would invoke. I think this is one of a couple more slides on the immigration pieces of it, but this is sort of a quick slide around FOIA requests as it relates to the immigration file. So FOIA is Freedom of Information Act. If you're trying to get, I definitely talk to a lot of advocates who are working with immigrant clients where the immigrant client might not even fully understand their immigration case, what their immigration status is, what's been filed, what hasn't been filed. And so sometimes it can be really helpful to know what to do next if you just have more information. And so filing a Freedom of Information Act request might be really helpful. And these are sort of my step-by-step instructions on filing a FOIA. So the first step would be to figure out what information you actually need. So that's my first step, because if you're looking for information on like arrests or convictions and how that might affect immigration, that's really more appropriate for like an FBI or a BCA background check, or even maybe a court records request that you don't actually have to reach out to immigration for that. But if you're looking for immigration documents, if you're looking for anything that happened in front of an immigration judge, any applications that have been filed for your client, that's appropriate to file a FOIA to some immigration agency. So then step 2 is figuring out which immigration agency will have that information. So there are various immigration agencies. There's United States Citizenship and Immigration Services. If any immigration applications have been filed, like a VAWA, like a U visa, like a family-based petition, employment-based petitions, things like that, will be with USCIS. So you would file with them. If you're talking about, my client was apprehended at the border, they don't know what happened, that would be more appropriate for something like Customs and Border Patrol. If you're thinking your client might have been arrested by ICE at some point in time, then you could submit a FOIA request to ICE, or you could submit a FOIA request directly to the immigration court. So this is a lot of information. One of the many handouts that we are providing you today is specifically kind of a step-by-step guide around how do I figure out what agency I go to, what forms do I fill out. So just know that there's a handout that I think is really clear in how you request a Freedom of Information Act request from these immigration agencies and what agency would be most appropriate. But if you're concerned about it or confused, you can always call me as well. Identify the reason. Step 3, identify the reason for requesting a FOIA. This can be really helpful to be specific on your FOIA request. The more general you are, the longer it's likely to take to get a FOIA response. So step 4 would be to fill out and file the FOIA. Sometimes it's on paper, but sometimes you can file it electronically, and it's pretty easy depending on the agency you're filing with. Most requests are free. This is another reason to be specific about what you're requesting. If it's less than 100 pages and it doesn't require too much time to look for, it's usually free. If it's a large request or requires a lot of effort to find, then there might be a cost that your client incurs. And then step 5 is wait. So depending on what agency you're filing with, FOIA requests can take anywhere from a few weeks to years. And so that's why it's important to make sure you're filing the right request with the right agency. So I do really want to encourage advocates to be filing FOIAs if their client isn't certain. FOIAs can take a while to get back. And so if your client is concerned about immigration, if immigration is something they should be talking to an attorney about or figuring out what their options are, just getting their file or getting information about what's been filed for them before can be really helpful in figuring out next steps. The FOIA application is usually very simple and something that can be done with the help of an advocate, doesn't really require an attorney to assist with it. And so we provided the guide, but please do reach out to me. I do think they're really helpful because information is power. All right, then the last immigration heavy slide is an exciting one. It's about recent changes in immigration policy, and most of them are good. So the first change that I wanted to talk about was just interim guidance on ICE enforcement and removal priorities. So as people are probably familiar, if you've worked with immigrant clients, over the course of the last 4 years, there's been a lot of tumult in the immigrant world. There's been a lot of changes. There's been a lot of concerns about raids and increased enforcement actions. So part of what the new president did when he took office was he asked ICE to review their policies and to issue guidance around it, their policies. So they did. They issued interim guidance in May. It lists the presumed priority categories to include people who are a threat to national security. So think terrorism, espionage, things like that. Threat to border security. And so this is going to be people who are apprehended at the border or who entered after November 1st, 2020. So that's kind of a, if you've recently entered the US illegally, you're going to be more of a priority than someone who's been here for a while. And then the last one is threats to public safety. So if you're someone who's committed an aggravated felony or you're involved in a gang-related offense, that would make you a priority for ICE to arrest and put in removal proceedings. So that means that the other categories doesn't mean you can't be arrested, but it does mean that you're not a priority, a listed high priority for immigration and customs enforcement. And this is these guidances, these policies are also supposed to fit with the government attorneys that are trying to have people deported through immigration court. And so those priorities, if they're saying if someone is not a priority, that might be a case that's less likely to move forward. Maybe they'll continue it, maybe they'll allow for other options, or they'll close the case. Again, there's no guarantees, but it's great to have this guidance out there that's a little bit friendlier. There's also guidance on limiting courthouse arrests. So that was also something that people were really concerned about in recent years. Like, should I go to family law court? Should I get a protective order? What if ICE is waiting for me at the courthouse? They recently issued guidance that it's going to sound really familiar to the other priorities I just talked about. But the guidance says that immigration arrests should only be carried out if it's a matter involving national security, if there's an immediate risk of death, violence, or physical harm, if they are in active pursuit of someone and it's a threat to public safety, or if there's an immediate risk that evidence is going to be destroyed. So some pretty selective circumstances. But that doesn't, and I do just want to make clear, that doesn't mean that they cannot arrest you. There is nothing that necessarily prevents ICE from entering a courthouse in other circumstances, but this is the guidance that they have around that. So I have advised some advocates, if there continues to be concerns around it, to maybe print out that guidance and have it with you. So if they ever were encountering ICE at a courthouse, that you could politely remind them of their own guidance and the circumstances in which they're supposed to be making arrests. Another exciting development has been in U visas. I'm going to talk about this real briefly. I don't want to get into too much detail, but for anybody who's helped anybody on a U visa case, one of the really difficult parts of a U visa case is that it is so long. From the time of filing to the time of getting a final decision, it's about 10 to 12 years, which is a long time. And typically it takes 4, 5, 6 years to get on a wait list for a U visa, which is the first time a person can get access to a work permit. That is a long time to wait without any protection from removal, without any ability to work or support yourself and your family. So immigration recently came out with this new process called a bona fide determination work permit, a bona fide work permit, where in theory, they're going to be giving work permits faster in U visa cases. We haven't quite seen this play out. We know that some people are starting to get issued these, but it's not quite clear what the timeline of the issuance of a bona fide determination work permit is, but it's an exciting development. Hopefully they'll get work permits faster. And then the last one would be, you can now include new spouses on UNT visa applications. So what that means is previously, if you filed a U or T visa application, and then after you filed it, you got married, that spouse could not be included as a derivative family member on your U or T visa application. Derivative family members, if the principal applicant, so I'm a victim, I'm applying for U visa, I'm including my spouse or child on it. When I get U visa status, they will too as my derivatives. So if I wasn't married or didn't file for my spouse when I wasn't married to my spouse when I originally filed the application, I could not include them. U visas are taking 10 to 12 years. There's a lot of time there where a person might get married. So the new policy is that if you get married while your application is processing, you can now include them on your application, which is exciting. All right, we're moving out of the super heavy immigration stuff and into some more discussions around how immigration sort of plays out in the family court context. But I think this slide is still near, right, Beth? Wonderful. Okay, so how an immigration application might impact, or how a divorce might impact that immigration case could be through a loss of eligibility, especially if the person that you're working with is a derivative or their status is based on their marriage to the abuser. So I'm going to talk about it mostly in these sort of 3 bullet pointed contexts. So if you are working with someone, if the victim is a derivative on the abuser's case, let's use a U visa, for example. So the husband is the person who filed the U visa case. They're the victim of a crime. They filed a U visa. They included their spouse on the U visa case as a derivative. You maybe have been waiting for a very long time to get a U visa, that 10 to 12 years, right? And now you're considering getting a divorce. Your derivative status is dependent on the marriage. So if you get a divorce, you will no longer be considered a derivative and you will no longer be eligible to get a U visa on that case. So that can have a real serious impact on someone who's maybe been waiting for 9 years, 10 years to get immigration status. And now, you know, getting a divorce would take them off the list. So that's one circumstance where it can be a very difficult decision. The second would be if an abusive person, so they petitioned for their victim spouse, let's say. If they get a divorce, that petition, that family-based petition, is no longer valid. Also, if you've already filed for a green card based on marriage, let's say, and they withdraw the green card application, that could also put you in removal proceedings. So pretty serious consequences. And then the last one would be if you have that 2-year marriage-based green card, and now all of a sudden, like, you are supposed to be filing this application together to remove those conditions, and you're getting a divorce. So all of those things, a divorce can impact the immigration case. I just wanted to note that even if you got your green card based on marriage, if you have a 10-year green card, so not a conditional 2-year green card, divorce isn't going to have any impact. I also wanted to note that if you're someone who's considering filing a vow of self-petition, you get a divorce, you have to file that vow of self-petition within 2 years of the divorce. So there's a bit of a timeline on that.
I think before a standpoint, I practiced in family law for 6 years, and I had a lot of clients who didn't have status in the US, and it was like no matter if I had an immigration attorney tell me 30 times in a row that a 10-year green card divorce has no impact, each and every client, I would, before we started anything, I would recheck with an immigration attorney, and I would recommend the same, even if you know, just check. Be safe, because if if your client is the one starting the proceeding, the immigration attorney can give them other, you know, if there's any other options. It may just be the advice that you have to wait. If the other parties, the one starting the divorce, they don't have the option to wait, but they might be able to get some other options. I would just make it a practice if you have a client who doesn't have status to encourage them to check with an immigration attorney each and every time.
Right. And this sounds very dire, and it is, but in a couple of slides, we're going to talk about potential solutions around, yes, this sounds really bad, but you might have other options. We're going to talk a little bit about annulment, because annulment comes up sometimes. People are wondering, okay, I'm a derivative on this person's application. I still want to be a derivative on this application. So instead of getting a divorce, what if I get an annulment? And it unfortunately is not typically that easy for a variety of reasons. So first, getting an annulment might mean that you're saying this marriage never really should have happened. This marriage never really legitimately happened, and that's why we're getting an annulment and not a divorce. Well, if you'd already told immigration that your marriage was legitimate and you got married for real, and now you're telling the court that you didn't get married for real, you deserve an annulment, you might be implicating yourself in marriage fraud, or the fact that immigration could consider that to be a marriage fraud. Also, often in the immigration context, they look at the practicality of what a divorce is. And if an annulment is a divorce for all intents and purposes, then they're probably still going to consider it to be the same as a divorce in the immigration context.
Yeah, and I would say, as a family law attorney here, I get a fair number of questions about annulments that clients are interested if they qualify for one. And just from a practical family law point of view, usually the answer is going to be no, you're likely not going to qualify. The availability of annulment is very limited. And even if your client does qualify, you have to file in a very timely fashion. Just really briefly, like you'd have to show that one party could not have given their voluntary consent to the marriage, like because of mental illness, under the influence of drugs or alcohol, or consent was obtained by force or fraud. You have to file for that annulment within 90 days after you've obtained knowledge of that condition. So 90 days, really quick. Plus, in a lot of these, there's a bar to an annulment if you've had any form of voluntary cohabitation after the marriage. So in most cases, if your client wants an annulment, likely wouldn't qualify, but that's definitely a situation where you should consult with both me and Rachel. If you would even qualify for it family law wise, and then if there's going to be immigration consequences.
Okay, so let's say you do have a situation where your client would like to get a divorce or like to separate, but that maybe they're a derivative on an application. They've been waiting for a long time. They have a family-based petition. They're waiting to get their green card. What are some potential solutions or strategies? So all caps, of course, refer to an immigration attorney. It's really important at that time, before they do anything, that they understand if they decide to move forward with a divorce, these are the consequences for doing that, so that they can go into it with eyes open. So in some circumstances, depending on where the client is at in their application process, an immigration attorney might advise them to wait. It sucks. I kind of hate being the immigration attorney that's like, stay in this crappy marriage because it's good for your immigration case. But if you're at the point where maybe they petitioned for you, you already attended an interview with immigration, literally you're waiting for the green card to come in the mail. You know, if you're waiting for that last bit of the immigration case to play out, it might make sense to wait. Because especially if you're getting your green card, you know, once you have that green card in hand, you can, even if it's a conditional green card, you could file the waiver of the marital conditions, you could do something with that. If you don't have the green card in hand, if it hasn't been approved yet, then you have to go back and start over with that VAWA petition, start over with the green card application. And it's just way more time intensive, potentially cost intensive. And so sometimes in those circumstances where it makes more sense to wait, the immigration attorney might advise that. If you're a derivative on a person's case, so again, I'll use a U visa as an example, just because the time period in which it pens is so long. So if you've been waiting for 10 years and you're at the point now where, and maybe you have a work permit based on that because your case is put on the wait list, and so you're able to work, but you know, you're almost to the point where that U visa is decided. It might be a circumstance that you want to wait on, or maybe if you're in the early part of it, the U visa was just filed, you're a derivative on it, now you're a victim of abuse, maybe it makes sense to file your own U visa application if you reported that to police. Or if another immigration application makes sense, maybe you want to file your own immigration application. This comes up a lot in U visa cases, again, because of how long it takes to process. So it's difficult in cases where maybe you're somewhere in the middle. You've been waiting for a few years, you've been waiting for 5 or 6 years. Maybe you have a work permit and you're working on that. And getting a divorce would mean you're no longer on that wait list. All those years of waiting, you'll have to start over again, even if you can file your own U visa, and that work permit will go away. That's a really hard thing that's a hard decision to make. And so part of what I do at Standpoint is I just talk very plainly with clients about these are the pros, these are the cons. It's up to you to make that choice, but I want you to do it with your eyes open, having all the information that you need. If the abusive person petitioned for the victim and they haven't attended their interview, they might be able to convert that family-based petition into that vow of self-petition. That's something that I also talk about a lot with callers. So if they're waiting maybe for an interview, they don't want to go to the interview because part of the interview is talking about how good your marriage is, and I would not recommend lying to immigration. There's a lot of potential consequences to that. And so what I tell them is to inform the service center. So inform the St. Paul Service Center here, whatever service center their interview is at, that your application is being converted to a family-based one into an abuse-based one. And that's something that I can talk about with clients about how to go about informing the service center of that. And legal separation comes up a lot, Beth, so I was going to let you take that away.
Yeah, I know a question I had for Rachel was if divorce is going to put you in a bad position or put your client in a bad position, what about a legal separation? I think the danger that we've come up with there is that it's just kind of within an annulment. It's a legal separation. It's not technically a marriage because purpose of a legal separation is it does everything but dissolve the bonds of matrimony. But on paper, especially in Minnesota, legal separation, you still file a petition. You're still deciding custody, parenting time, dividing all your debts and assets. It is the process of a divorce without ending your marriage. Yeah. And then if you want a divorce, you start all over again. So I think immigration very well may still view that legal separation.
I think this was, I don't know if they do DARE classes anymore, but I remember in DARE, they would say like, if it looks like a duck, it sounds like, or quacks like a duck, then it's probably a duck. And so immigration looks at that the same way too. Like, is that what it was? It was something like that. But basically like a legal separation for all intents and purposes looks like a divorce. And so immigration isn't going to necessarily let you slide with, I'd still like to be a derivative on this application because technically we're still married, even though everything we just went through in court is the process of a divorce with the exception of ending the marriage. And so it's not usually something I recommend to sort of get around the immigration stuff.
Okay, so what are some things that you can do or your client can do if immigration status is made an issue? So usually the reason your immigration status would be made an issue if the other parent raises undocumented or temporary immigration status because they want to prejudice the decision maker. They want to prejudice the judge. They want to say this person who doesn't have status is unstable. Who knows how long they're going to be here. It's not safe for the kids to be with them. They can't support themselves. They coerce me into marriage fraud, whatever it may be. I've heard it all. So just some things to do, just kind of touching back a little bit about what we recapped is what your client can do is focus on the relevance of the abuse, including if that's some immigration-based abuse, and shift the focus back to the abuser and their actions. Remind the court that immigration status is not a best interest factor, and instead can emphasize the relevant factors that do exist. Like if your client has been the primary caretaker, and that would be the status quo for the children, that mom has been the one taking care of their needs and their special needs in the past and is likely going to be the one responsible for their education and healthcare in the future. Emphasize that they do have a support system here and they do have financial support here, and that children of immigrant domestic violence victims should benefit from the same laws and protections that benefit children of citizens, such as awarding presumptions against awarding custody to abusers. And you can help dispel some myths that are provided by the other party, and that's kind of, we get into that in a little bit, some myths about undocumented parents that you may hear in family court. And like Rachel was saying at the very beginning, you know, in a lot of cases, it can be best to keep immigration status off the table altogether if possible. But if not, you can do things like raise your pending immigration applications, you know, steps that you're taking to stay in the country as an affirmative defense to that, especially if the judge is expressing a concern.
So like Beth was saying, we're going to go over some like fact v myth scenarios, and these are, or dispel some myths with facts. These are scenarios that are specific to custody and parenting stuff. And so one of the myths is that, you know, don't give custody to this other parent because they could be deported any day now. Lack of immigration status does not necessarily mean they are about to be deported. And there may be a variety of defenses to that. Specifically, if you are a victim of domestic or sexual violence, there's a likelihood that you might be eligible for some form of relief. I talked a while about that on an earlier slide. Another reason why getting an immigration attorney involved alongside of a family law case might be helpful. But also, if a person lacks a criminal history, there's a great likelihood that they're just not on the radar of Immigration and Customs Enforcement, that there's not a great likelihood that they're going to be arrested and put into removal proceedings. So there's about 11 million people in the country that don't have documented status. Immigration and Customs Enforcement, immigration detention, and immigration courts do not have the capacity to remove all of those people. And so that is why there is enforcement priorities. And there's been new enforcement priorities to really focus in on the people that they believe should be prioritized in arresting and removing from the country. And so if your client doesn't have a criminal history and isn't one of the people who fits into those priority categories, there may be a very good likelihood that they can continue to live without being involved in the immigration system at all. But what if they do? What if they are arrested?
There are some steps that anyone can take if arrest by ICE is a possibility in their lives. They can come up with some kind of plan in advance. I guess any parent can, about who's going to be their contact person, who's going to be their person to do emergency things like pick up kids from daycare and provide care until they can. Some reasons that victims can end up in immigration detention are listed here. Abusers report them, traffic stops, enforcement at work site. Usually it's not something that they anticipate, and it happens maybe when they're not expecting it. So it's good to have that plan in advance. We have some just information here on how to locate someone if they're in the ICE system. We have a handout on how to get a detained parent to a family law proceeding if they are going through a family law proceeding while in ICE custody. But just some other tips is that someone who's picked up by ICE in a situation like this, who is a parent, can tell ICE that they have children. They don't need to be detained, and they'll continue to comply with their directives. They can repeat that to each and every ICE officer that they meet. If their children are with them when they're detained, they're probably in the best position to convince the officers that they need to make a phone call immediately to have someone come and take care of the children, which is when it's good to have that person in mind who's going to be that contact for you. If children are not in the care at the time, again, tell the ICE officer immediately that you have kids and you need to make a phone call to take care of their needs. I should let you make a phone call to your caretaker or emergency contact and asking that emergency contact to follow the emergency plans that you have in place. So it's advisable to know those phone numbers by heart. When you get an A number, write that down immediately and provide it to your children's caretaker so they can find you in that system we have listed there. And if your client is in detention while a family court proceeding is going on, they should interact with their kids as much as possible. Phone, letters, ask for the court to order visits if they're in detention, just to maintain that relationship and their position in the family court case. Through this brochure, there should be some more steps, but you can ask your family court judge to require ICE to transport you to family court for a hearing. It's always best to participate in person if that is being offered and that is possible. Keep everyone, family law attorney, guardian, if there is one, judge, updated on your immigration case, what the next steps are, what the next hearings are, and if your detention is not making it possible for you to participate in the case to the extent that you would like, to keep them updated on that. And I think on the next slide, we have just some specific information to Minnesota about how to contact ICE. So the handout from before is a little more general. This is, if anyone needs it, how to contact the local field office directly and speak with the parental interest field liaison.
So, and the only thing thank you, Beth. I did click on, just because I always like to give I'm like, what is the ICE detainee locator look like? So I clicked on it before we did the presentation. It's pretty easy, actually. If you have the person's alien registration number, which is like the number, kind of like the immigration social security number, like it's the number that's on their file. It files their immigration case from like A to Z. It's 9 digits, it's on all the court notices. But if you have that number in their country of birth, that's one way of looking it up. But if you don't, you can look it up with first and last name and country of birth and date of birth if it's a really common name or something. And I do think, that ICE parental interest directive, they have a directive about how they can't let people who are in immigration detention not participate in these family law proceedings. And so that handout is really handy in just giving you those step-by-step instructions and so they're in detention. How do I get them to appear ideally in person at these hearings? And a big part of that is reaching out to your local ICE office. And so you have the phone number for it there, the email for it there. It shouldn't be, they should be pretty willing to work with you on getting someone who's in detention to a hearing.
Okay, another common myth that we hear in family court proceedings that are tried to use against the parent without status is that the non-citizen parent is likely to flee the US with the child. In reality, that's just not the case. Someone who has status like a citizen, legal permanent resident, and those with visas have a lot more freedom to travel freely to and from the US as opposed to someone who's not documented. The undocumented parent or a parent with temporary status are the one who are in this long process of pursuing status. They're less likely to flee because it can trigger a bar to reentry into the United States. So I think practically they know that if they flee with the kids, they could find themselves in a situation where the children can very much reenter the United States, and it will kind of cover on the next slide, very well may be ordered to do so, but they won't be able to join them. And that's a risk that I think a lot of parents would not be willing to take. So if a party is making that accusation, urge the court to require them to back that up a little. Show, do they have proof of that they've actually gone ahead to purchase an airline ticket, showing that they have any plans to move to another location, proof of contacts or family or jobs in another location, and do they have the economic capacity to make that move? And I think in a lot of cases, the case can be made that, no, this person is very much trying to stay in this country that they chose to move to. They're trying to make a life here and they have children here. A lot of cases who are citizens and they very much want to stay with them, especially if the other parent is abusive. And just practically, we don't have to go over this in great detail, but just kind of a reality to that myth is there are huge challenges to taking kids out of the US in terms of potential legal consequences. Like if in Minnesota law, if there's any parenting time ordered, you can't even relocate out of state without the court's permission or the other party's permission. And so that's very much a situation where a parent could be facing a court order that the children have to be returned immediately. If they were ever to return and face that court, they're going to have a really hard time obtaining custody and proving to the court that they wouldn't do that again. The Hague Abduction Convention has been put in place and signed on to by a number of countries to protect from this exact thing, from international abduction by a parent. And basically each country that signed on has a process in place to try and locate a parent that has taken a child from their habitual place of residence and then return the children. And that's very much something that if your client or anyone wanted to flee to a country that's a signatory to that, there is a process in place to get the children returned, and the parent who wants them returned can file that application online to try and get that process started. Not all countries are signatories. It'll vary really greatly in how much they're actually compliant in enforcing it, the country, but I think that plus the fact that we have this federal law at the bottom, 18 U.S. Code 1204, they could be charged with international parental kidnapping, is all just meant to show the court that this is kind of your defense, that this parent is not going to flee with the children. They are well aware that doing so could have significant consequences for them and their children and their ability to get custody in the future.
Okay, time is flying, so I'm going to go through the next one kind of fast. And so just to put on people's radar that if you're working with someone who is trying to file for, typically this comes up in the case where mom is trying to file for a passport for their kids. It is really important to look at who is on the birth certificate. We're not talking about recognition of parentage. We're not talking about legal custody. We're talking purely about names on birth certificates. Because the Department of State looks to the birth certificate, and if there are two parents listed on there, they will deny without the consent of both parents, regardless of the fact that a name on a birth certificate doesn't give a father legal custody or legal rights to that child. So some options if you're working with someone who's trying to file for passports for their children and the other parent is abusive. There is a consent form that they could sign. So if one parent is trying to get a passport and the other parent is willing to sign this consent form, they can go in with that consent form and file for the passport for the kids. Obviously, in cases of abuse, that might not be a good option. There's also this other form called a statement of exigent or special family circumstances. So like if you can't locate the other parent, if they're in the wind, if they've been deported and you don't know where they are, or maybe if there's abuse, you might be able to show that there's like a protective order, there's a criminal action. I've heard from advocates who have tried to use this particular form that it's not generally successful in getting the passport issued. So another option may be filing a motion in court specifically and solely addressing the passport. And so that can be complicated because you may not want to file for custody. You may not want to include all of those extra things which might cause additional problems between parents and abusers. And so maybe you only want the court to deal with the issue of who has the legal right to ask for this passport. Some courts have been really friendly to that as an option. I know the 4th Judicial District created these sample motion paperwork that you can file with whatever court in your district, which we have provided in the handouts. I've worked with advocates who have had success in filing these passport only motions, and I've worked with advocates who have not. So unfortunately, I think it depends on your county. I think it depends on the judge, but I definitely think it's worth trying. If that doesn't work, maybe your last ditch option could be to apply for full legal custody, either through a protective order or through family court action. Again, that might be a better case in a circumstance where the other parent is no longer in the picture, where it might move forward by default, as compared to now invoking the fact that the other parent might want custody, might want child, especially when child support and finances are being questioned, they might be more interested in getting some parenting time if it decreases their child support obligation. So It can be, depending on the circumstances, not the safest thing to do. But if you're in a circumstance where it's your only option, it might be safe to do, that might be the only way to move forward with getting that court order. You have that court order with custody or that court order saying this person has the legal authority to apply for the kid's passport. You can take that with you to the passport office and apply for the child's passport.
Yeah, thinking back to that mom with the SIJS status who thought ahead to put in her petition for SIJS status, that'd be a perfect example of when throw it in there and put it in your requested relief that you want to the court to say you are specifically granted permission to apply for a passport for these kids without their parents' participation or consent. That's the safest way. I'd say that's the probably thing the passport office would be most comfortable with, that kind of language. And so if you can get it, great.
Yep, I agree. It looks like we have a question that came in. Janet is asking, if a parent has full legal custody, but there are two parents on the birth certificate, can the parent with full legal custody apply for the passport? So generally, yes. So if you go into the passport with that court order giving you full legal custody, that typically is sufficient. But as Beth was saying, if you're questioning it, and it wouldn't hurt to have a specific finding in that court order, specifically giving the parent, maybe with legal custody, the authority to apply for those passports, should there be any question. But typically, I would say that answer should be yes, that they can apply for it.
It does say on the website when you're looking at a passport for minor that sole legal custody should be sufficient. I've heard anecdotally from a client that they have been rejected, which is what kind of put in my head that if it seems like a safe option, throw in that relief specifically mentioning the passport so that there won't be any question.
Yeah.
Okay, so another myth that kind of we went over that may be used against parent without status is that immigrant parents cannot financially support their child. So in reality, they may be eligible for immigration relief, such as the VAWA self-petition, and may receive some work authorization and some benefits. We'll go over in the next slide that in a lot of cases, the child themselves may apply for benefits. And just remember that if a parent, an abuser, is the one throwing out this concern, well, she can't work. They can't financially support the child. There is a such thing as child support. There is such thing as spousal maintenance, and they should be financially responsible for that. You know, the argument can be made that they should be financially responsible for that spouse and those children. Okay, so just we can kind of go through these quick because I know we're running out of time, but just, you know, benefits that parents may obtain for children. So like any US born citizen, US citizen children of undocumented parents can receive federal benefits if they meet eligibility requirements without penalty. So Supreme Court ruling that all immigrant children, regardless of status, have access to a public education and are eligible to attend public schools for grades K through 12. So parent without status is just as able to send their children to school, make sure they get a good education and participate in that process. And undocumented immigrants are also eligible for Head Start, as it's not considered a federal benefit program. Any child who's otherwise eligible, regardless of immigration status, can enroll in Head Start or Early Head Start. So again, kind of countering that myth. They can't support, they can't provide. That child is just as eligible as any other child to go to Head Start. So some things like food benefits and healthcare. We can go through this kind of quick, but food benefits are available to qualified non-citizens and children under 18. Qualified non-citizen is a little bit different from benefit to benefit, but it could be if you have a green card, you're a refugee, you've been granted asylum, have a T visa as a victim of severe trafficking. And for some of these cases, if you came into the United States with a sponsor, the sponsor income in some cases can be counted against the parent. They may not qualify for benefits because their sponsor income is counted, but that can be counted in a couple ways. Sponsor income is not counted as income for children under the age of 18, so that undocumented parent can still provide food benefits for their children. And sponsor income may not count if you can show that you would be living in severe poverty without food if they counted it. or if your sponsor is your abuser. Healthcare, if the abusive parent is trying to say this parent is undocumented, they can't keep the child safe and insured. Again, for a parent, they have to be a qualified non-citizen, but children who are in the US legally are eligible for MA. That includes children who have that temporary protected status or who have applied for but don't yet have asylum. And then an undocumented mother who's pregnant is going to qualify for MA throughout pregnancy and 2 months after birth, regardless of immigration status. And a client who does not qualify for MA based on immigration status may qualify for emergency medical assistance, which is obviously pretty limited. It's for emergencies, but there are some options out there. And then cash and fit benefits, again, if your client is not a citizen, but they're, again, considered a qualified non-citizen, temporary protected status, have DACA status is all an example of that. They could qualify for MFIT benefits to help support their children, themselves and their children. And that's another case where if their abuser is their sponsor, that sponsor income may not be counted.
And I'm gonna, again, because we're running out of time, I'm gonna go through this slide kind of fast, but something that I encourage people who have these affidavits of support to use in like negotiations for child support and maintenance in a divorce. So when you have been petitioned for in the family petition process, so let's say your spouse petitioned for you to get immigration status. There is a requirement that somebody, that person, potentially on their own or with a joint sponsor, file something called an affidavit of support. It's that form I-864. What that is it is it's a federal legally enforceable contract, a statement, a sworn promise made by the person with status that they will not let their family member fall below 125% of the federal poverty guideline. And it's actually, Andrew and I were kind of like arguing about it earlier today because it is a really like hefty contract. You can't get rid of it in a divorce. So even if you were married and you sponsored this person, a divorce doesn't get rid of that contract. You can't get rid of it in bankruptcy. Like it is really hard to get rid of this contract. The only way to get rid of this contract is if the family member naturalizes, becomes a citizen, or if they leave the country for good, they no longer want to be in the United States, if they pass away, or if they have worked for 40 quarters of work, which is about 10 years of work. So it is a hefty contract that you are making with this person. Typically how this would be enforced, so like if the sponsored immigrant applies for public benefits, they should not, because they should be counting the sponsor's income. That if they do and they happen to get benefits, the government could sue the sponsor for repayment of those benefits that they got. I don't know how frequently that happens, but it is technically something that could happen. And also the immigrant could actually sue the sponsor for the money that it would take to get them to 125% of the federal poverty guideline. So when you're in negotiations for spousal maintenance and child support, this is something that you can use to say, hey, there's this enforceable contract. We could go to court and enforce it, or in this process of figuring out child support and spousal maintenance, we can kind of figure out how to keep this person who may not have a lot of options as far as legal authorization to work, how the spouse can support this person to the point where they are not in poverty and needing to apply for public benefits. The reason I keep talking about it in negotiations is I think it's more likely to be successful there. I think judges might get a little oogie about it and, if you bring it up in the trial, but I think it can be a really good bargaining tool. Did you have something to say about that, Beth? Oh, yeah.
We have another question here. The question is, I'm working with a client who, a citizen, I'm thinking that who is a citizen and who is sponsoring her husband for an I-30 petition. They're in the middle of divorce currently. Is she still required to financially support him? If so, for how long? Do you have any tips for how to withdraw her petition so that she filed to support his application?
So unfortunately, first I would want to know where they're at in the process. So if they've just filed the I-130 petition, they just filed it with that affidavit of support and it hasn't been decided yet, then they have time to withdraw. They can withdraw that I-130 petition. If the affidavit of support hasn't been granted, then there's no enforceable contract. However, if the I-130 petition and the affidavit of support have already been approved, there's no way to withdraw it, which is sort of what I was saying. The only way to get rid of that contract would either be for that family member to naturalize, for them to leave the country, for them to pass away, or for them to work those 40 quarters of work around 10 years. That's really the only way to get rid of the contract. So that the person who's sponsored is on the line to continue to sponsor that person until one of those things happen. Again, regardless of whether or not they remain married or not. Divorce does not get rid of that contract. So I guess I would want to know where they're at in that process. Can they withdraw the petition already? And if they can't, then just sort of giving them the bad news that there are really limited amount of circumstances where you can withdraw or no longer be or no longer have to support that person financially. I mean, I will say, again, the likelihood that they'll be sued is probably pretty low. I have not seen it happen in too many cases. So it's a risk. I mean, they certainly could be, which is why I think it's a really good bargaining tool, because you could say, hey, you could be, but I think the likelihood of that happening is low. Oh gosh, and we have 4 minutes, Beth.
All right, we'll go through this. So just now we're kind of moving on to civil protective orders and some considerations in the immigration status, immigration context. Basically, if your client's a petitioner, like Rachel talked about, a finding of abuse or an arrest for violating a protective order can be a real motivating factor, because either of those things could lead to repercussions for them in the immigration context. But for others, this may not be helpful. Your client may fear deportation could have enhanced dangers to them because they could lose any form of economic support from that other parent. Or sometimes they fear for their family abroad if their abuser is to be deported back to their home country. And just remember that evidence obtained from a civil protective order can provide crucial evidence of reoccurring abuse and can help an immigrant file for immigration benefits, including battered spouse waivers, self-petitions, cancellation of removal applications, etc. And then we just have a note that immigration survivors might have a distrust of the legal system and be afraid to file for protective orders. That may be very well something their abuser is telling them, and they may have lived in countries where abuse of women, especially in the context of marriage, was not taken seriously. So they have learned not to expect justice from the legal system. If you are working with a victim who's ending up as a respondent, someone's filed against them, retaliatory or otherwise, first refer them to an immigration attorney, but likely what they're going to say is the obvious best case scenario is a dismissal, getting that off their record, but going to trial is a risk because the court could issue an order for protection with findings of abuse. And so then not only do they have an enforceable order that they could potentially violate and get arrested for, and they might have an abuser who's very much trying to get them to violate, but it would also be an order with findings of abuse, which could potentially go to their moral character, according to immigration. So refer to an attorney who might say that accepting an order without findings is the best scenario in this situation. You can discuss settlement options such as limiting the duration and say you'll agree to a year instead of 2 years. Discuss settlement options like if there's an active family law case and trying to make it a civil no protective order in that family case as opposed to an enforceable order for protection. And always advise of the consequences of violating that OFP, and advise on practical things like even if the abuser initiates contact, doesn't matter, you will be violated. If you see them in a store, you leave because you could be violated. If you are in the position of working with a petitioner in an OFP, keep in mind that you can ask for some creative remedies. 518B.01 lists all the potential relief in an order for protection, and down there in subdivision 13, they have a catch-all provision that the court may order in its discretion other relief as it deems necessary for the protection of family or household members. So it kind of leaves it open. And if you're looking on a petition, you're not going to see a box to check for this. You're going to see a box labeler. You're going to check that and maybe write in some of these things that we're suggesting. One thing that we are suggesting is the they can ask the respondent to get them related to or needed for their immigration application. If the abuser is the one who filed the immigration papers, the victim may need copies of them in order to support their own case, can use the documentation to help prove the abuser's immigration status. And so advocates or attorneys working with someone with this protective order should consult with an immigration attorney to find out basically what documents are you looking for. And then in all of these creative provisions, put in what do you want to happen if the respondent abuser doesn't follow through? How are you going to make this enforceable? So if they fail to execute, is it going to be a violation of the order? Is it arrestable? What are the consequences? Another creative provision is that the respondent shall pay any and all fees associated with the petitioner's and or children's immigration cases to ensure that any financial burdens won't fall on the survivor, but will fall on the abusive party. And there are fee waivers when you apply in immigration, but those can delay the case, cause the immigration official to question if the survivor is going to become a public charge. And also just on a practical matter, fee waivers are getting denied in much greater numbers.
Although that's getting better. I think when we initially wrote this, it wasn't, the fee waiver stuff is kind of being reversed, but also like if they have an affidavit of support, so they should have been paying for these things in the first place. I think that's a really good argument to say like they were gonna have to pay for it. They should still have to pay for it.
Another creative provision, if the respondent claims that the documents are destroyed, hidden, or missing, ask that the respondent has to be the one to pay for replacement of the documents. That can include, but not limited to, passports, green cards, social security cards, birth certificates, work permits, etc. By requiring that the respondent be financially responsible, they're less likely to actually destroy them. And the destruction of these documents can affect the survivor's right to work or establish their identity. And purchasing, obtaining all new documents is going to be extremely expensive and time consuming for your client. So this is some creative relief you can ask for to hopefully avoid that problem.
It's also amazing how people will be like, I can't find that. I don't know where that is. And when it comes to like a court ordering there, they're like, oh yeah, there it is.
Okay, we have a couple of other ideas for creative provisions that the respondent shall sign a prepared FOIA that Rachel went over. With the results of this form to be sent to the petitioner or the petitioner's attorney. A signed FOIA form can be used to obtain copies of their immigration case file and all any case that the respondent has filed on behalf of the survivor or the children. It can include a case in which he obtained lawful permanent residency, became a naturalized citizen, again, or the file that he completed on behalf of the abused spouse or children. So it can be especially helpful to include this if you have a respondent who's been withholding information regarding the status of the immigration petition filed on her behalf or documentation of her legal status. And quite frankly, if it's his application, he filed for himself, he filed for her, it's considered their application. The survivor may not be able to get a copy of it without this FOIA, so this can be extremely helpful relief. I think the last one is ordering that the respondent shall not remove the children from the court's jurisdiction or the U.S. absent a court order and shall relinquish the children's passports to the petitioner or the court. Because as we know, as a control tactic, batterers often threaten to abduct children. In some cases, they may actually carry out that threat. So this can help prevent international kidnapping. And if he has to give up those passports, gives up control, lessens his ability to threaten and abuse the victim. So it should be included in cases where the abusive relationship has included threats of parental kidnapping, should address the mechanics of how and when the passports are actually going to be turned over and what are the consequences for not doing so. And I think a case where it's a citizen abuser making that threat, you'll find that it may be actually more likely that he's the one, or he or she is the one to abscond, because unlike with the parent without status that we talked about, they're not going to have that bar to reentering the US.
And then the very last slide.
Yep. Basically, these are just some, when we talked about make a plan, if being picked up by ICE is a potential, make a plan to protect yourself and your kids. One such plan is to sign in advance a delegation of parental authority, also known as a DOPA. It's a document that lets someone else take care of your kids when you can't, and it makes them an attorney in fact. You don't give up your parental rights, but it lets them make decisions about care, custody, and property, bringing them to the doctor, signing them up for school, keeping care of them in their house. It's limited in duration to a year at a time. You may need to give notice to the other parent only if that parent has some kind of parenting time, some kind of parenting time rights. If their rights have been terminated, or their no parenting time rights, or it's supervised, the other parent does not have to be given notice of the DOPA.
And I think DOPAs were really popular to do sort of a few years ago when people were really concerned about the new enforcement priorities and being picked up and removed. And part of the reason that they were such a common thing to do was because they're super simple. Like if you've ever filed one, it's very simple to file. It's very simple to take back. It's a pretty easy process that pro se folks can do. The standby custodian process is a little more involved and actually requires them to file it with the court. So a standby custodian is a choice, but not one I would consider doing unless you're thinking it would be more of a permanent situation. And a power of attorney is also an option, again, if you're worried about being removed, where people can sort of handle your financials while you're away. We have a couple of handouts in the Dropbox around delegations of parental authority and powers of attorney, if that's something that your clients are interested in doing and you want to help them through that process. The end.
Yay.
Thank you everybody for sticking with us. I know we've gone a little bit over, but it was a lot of information. Again, we're here. There's our contact information. Please let us know if we haven't gotten a chance to answer your question today, or you have a question that comes up later. I don't know about Beth, because immigration is not necessarily your area, but I love this stuff. So please do reach out to me if you have any questions. I'm very happy to talk about it.
Yeah, we're always happy to hear from you. So thank you for attending.
Thank you so much, everyone, today for coming. Thank you to Rachel and Beth. And I don't see any further questions in here, so I'm going to end the webinar. Thank you all.
Thanks, everyone. Bye.